sort of thing, does that, that is to say, accurate in the terms that it's serious, but pejorative in the sense that it's critical, does that fall within standing orders?
Well, I'll just read, the member's answered his own question. I'll pick up Speaker's Rulings 1124 and read it. It says, an amendment of the title of the bill must be serious or an objective description of the bill rather than an attempt to criticise its contents. A pejorative, by definition, is a criticism. It is a negative. So by the member's own words, his objection fails because it does not meet what Speaker's rulings have ruled before.
We're getting somewhere on this, so just hear me out. I think what Mr Hodgson is putting to you is there any test for the amendment to the title by a government minister on a bill? Because SOP 111 changes the name of the principal act and gives it an emphasis that doesn't marry off the other two things that the existing law does: injury prevention and rehabilitation. So what I think we're trying to ascertain is if opposition amendments can be struck out on the basis that it's possible it could be perceived as a negative criticism, although there's no, in a couple of ones that have been ruled out, there was no criticism, it was just a statement of fact. Does that same standing order, Speaker's Ruling 112/4, does that equally apply to government amendments? Because we're going to shortly vote, once we've voted on the amendments to the amendments, on an exact example of this from the other side of the chamber.
The member is correct that a government amendment, which was a negative, would be ruled out accordingly. But as I see the government's amendment, it is not a negative. It might not cover the traverse the ground the member desires to have in it, but it is not in itself a negative.
Oh, this is not ridiculous.
I'm getting to the...
But let me see
Certainly
if
are.
we might need
I call
to
the Honourable Pete Hodgson.
We might need to go to the Speaker now or at some later time to try and get clarity around this. The Speaker's ruling has got two parts to it. You've read it out to us more than once, and thank you for doing so. The two parts are that the amendment must achieve certain things. It must be a serious amendment to the title. It must be a serious amendment that describes the legislation on the one hand, and then the Speaker's ruling goes on to say, rather than a criticism of the legislation. Well, you see, the problem the opposition has is that a serious description of the title, accurate description of the title, may be, and we would assert in this case, must be critical. And so it's no fault of yours, dear Mr Chair, because it's a Speaker's ruling from earlier times. But the Speaker's ruling has got two parts to it, as if one of the two must be true. And in fact, it is easy to show that an accurate description of legislation must, in order to be accurate, also be critical. And that is, in the essence of it, our conundrum. And the problem for you, Mr Chairman, if I might be so bold, is that you are obliged to choose one of the two parts of that dichotomy. And we would assert you should choose the other.
Well, it's the Chair's decision, and I've heard plenty on this, and I just want to make the point again that the amendments to the title are to be serious and to be an objective description and are not to attempt to criticise the contents. And many of the amendments I've ruled out do exactly that. There's no question about that. There are some, and I'm just coming to them, which are a serious amendment in my opinion and do not attempt to directly criticise the contents, and I want to move on to these. And the name first of these, in the name of Darian Fenton, is an amendment to amend the title of the bill to the Injury Prevention, Rehabilitation and Compensation Rebalancing between Non-Work and Work Accounts Amendment Act 2010. Now those who support that amendment will say aye. Aye. The contrary will say no. No. The noes have it. Party vote. Clerk, please conduct a party vote.
New Zealand National, 58 votes opposed. New Zealand Labour,
43 votes in favour.
Green Party,
9 votes in favour.
ACT New Zealand.
5 votes opposed.
Māori Party.
5 votes opposed.
Progressive. United Future.
1 vote in favour for Progressive, sorry.
United Future.
1 vote opposed.
Members, the ayes are 53, the noes are 69. The amendment is not agreed to. We now come to the second amendment in the name of Darian Fenton.